Imobi bi akwaba eba Melodies TV so. Finally, the Attorney General Obi Besie shamelessly has appealed to the Supreme Court. Na say enra ena yete se sisia no de asem na court na ne nsem no ejina 6. I mean, should I even read? Okay, so he now has 6 grounds. Okay, he's appealing at the court. He's appealing at the Supreme Court, appealing the Court of Appeals acquittal to Atuforsin based on 6 grounds. Now we are going to go into it and then we are going to see what the Attorney General is saying. Now, one. Or granted say court no money to release. Okay, the Attorney General is praying the apex court to grant him 2 release. Now, one, or say court no enrule say the decision and consequential order of the Court of Appeal dated 30th July 2024 acquitting and discharging the accused stroke appellant respondents be set aside. Enti adia was here who here ne pan a wodi akwa dan court nim ene se Atuforsin ene jakpa yeja wo mumu se wo mundi boni bia no court no embosa ruling ngu, and the Supreme Court has that power. The Supreme Court embosa ruling ngu say you say Atuforsin mundi boni omodi boni ati ase. Now I see Owia on se eba ne sa na ye ka se what it means is that they will now have to continue with the trial that is going on at the High Court. Okay, it is subsequent to granting of the first relief. Okay, the Supreme Court should give order. There should be a court from the Supreme Court that the accused Atuforsin any Mr. Jakpano, they should be ordered to continue with their defense at the trial High Court. Because na defense no air koso or High Court. And Atuforsin moko appeals court na appeals court bogu na tese sisi ama High Court case no adani beans ayegobe. Senya ye kana ewo local Ghanaian jargon terms emuno jargon emuno ati ase aha. Nti o say wakatre Supreme Court say ombo appeals court decision ningu to Obogua. On country Supreme Court say Supreme Court ruling was so say Atuforsin edi bone dabi. Supreme Court kase womon call back to the High Court no. No mon sanson ko tua case ne so a womudi wo High Court no mon sanson ko tua so. And I don't know, but you see the judiciary ankasa no, a lot of people, some people were saying say it looks like they will be going for a break. Maybe a break now wo mobeko no. Maybe o me so mbeba back no. Na se ye koto aba na nyama nti no na ebi mo ka se cases bi e da mu anim ni sisia na ebi age next year ne nsem bebre nkrofo bebre bi mo na mo ka sansem no. But the way it is looking like, the way the Attorney General has sent this case no, it doesn't look like it should take that long. Not just on court and near my ruling. The court near my ruling as a case so near so. And I kid you not, I personally think that this will be one of the quickest cases that will be called to the Supreme Court. On the case up till now, 2 years ni e-levy case ni the Supreme Court in Frey. The Supreme Court has still not called the e-levy case. Okay. And I want to believe that this will be one of the cases your best friend quick and then the cry. Now, Sani America, this appeal, it is on 6 major grounds. Now, the first one being that the majority on the Court of Appeal misdirected itself in the application of the fundamental principles regarding the standard of proof required in determining whether a case has been made for the accused persons to answer. Now, asemu ana Atuforsin, okay, omode koye ne say there's no evidence. Like I said, a case has not been made for them to answer. And you see, for a case to be made for you to answer, no, I was say you show proof. Mama, like example, you see, people think say what's some year there and a debia wujuane court. And you say always what's some year there. Sometimes what you need is evidence. Now, say evidence now what they back court no first no. Omo would accuse you, especially if it is a criminal case. Omo will accuse you, no. You have to be able to make a case against them. I don't know I'm not a learned person in the terms of senior lawyers never can no, but I'm say eno ne ya na efe no prima facie case no. Ndiye ka say prima facie case yema ne say obi ekun obi na nipa ko na wekun obi no yenya evidence etre say indeed ye betumi ahyase a prosecute nipa kro no. Evidence say bia ye hu say ni phone na ye check ni phone records na ye hu say bebi a nipa ko ne wuye no nipa ko no na ni phone bebe wo ho. Ebia ye hu ne say nipa ko no ye hu ni DNA ni bibi wo ho. And no a case has been made against that person. I was say nipa kro no obi any defense. But yemfa ne say yes obi ekun obi na ade no yenya evidence bia entia nipa kro no. Now so still ya court say ye pese ye chi nipa kro na tre say ade no untumi establish case. Inti wo hwe appeals court ruling na omo say attorney general no untumi establish ni evidence awode bae no untumi establish case entia atofo sen mu inti ye bo asem na egu ende 6 grounds awogina so awoka say Supreme Court embo appeals court insemingu ene say evidence awomoka say wono untumi fa establish case no sa evidence no appeals court for no omo entumi anhwemu yie omo ye misdirected in that evidence. Now the second ground and they say the decision by the two judges that the issuance of letters of credit does not constitute payment of monies is erroneous and, in his view, inconsistent with the evidence he adduced. Now, atofosing, memamoti asye wa ha say, directly no enye sika no tuaye, or ya debi efe ne letter of credit. Na letter of credit no matrate rimu wa ha, enye sika, ne diya ne say, ase, eye ahombambo, ni ye trel se we juma na oye no koso na ye na nipa kru sika wo ho a obetumi etia oka. Inti judges me ne tre se atofo na dia wo ye no enye aketua eye letter of credit e no sign ye. Inti ye ntia se se o pese wo chi ni tum because of letter of credit. Inti attorney general no ni case a wo kan se letter of credit no eye aketua etisa aketua pepepe. Etisa aketua inti e ka aketua ne ho. Inti se judges mienu e de ejina so de abo no na asem negu a Supreme Court judges no enhwem no monka no obi anti ase say letter of credit no eya aketua. That is the second ground. Okay. Now, owie no o say the decision arrived at by the majority on the Court of Appeal that the Ministry of Health should be held liable for the unfit nature of the ambulance and not the finance minister is error-ridden. On say memamoti ase say the deal no it is between the Ministry of Health and the company Big C. Inti judges no so nsemo mo kan no say atofos in your not in baby and the Ministry of Health dey abrane say one clear contract because of a finance minister, deputy finance minister. Inti na ka asem bi wo ho a Ministry of Health and a Big C company no e na enya asem. Na atofos na odi ni bem de ono de wa eden. E na wo ka tre judges no Supreme Court judges ne say omontremu say enye between Ministry of Health and the company no na atofos mo. Owie yan say the holding by the majority on the Court of Appeal that the establishment of the letters of credit did not constitute payment and that the contract is contrary to the clear evidence, and I've said that already. I say the majority's holding that the Ministry of Health's default caused financial loss to the state and not the act of the first accused in authorizing the establishment of letter of credit was laden with fundamental errors. Intino uti nsemo awoka na ni tintini ni tieti mu no. Appeals courts judges no say errors in kwa no omokoko make fundamental errors. Ati I say the majority of the Court of Appeal failed to appreciate the relevant factors in determining whether a prima facie case has been established for the accused person to answer. Ati I say sa case na me kind na the majority of Appeal's consideration of possible defenses for the accused person at the close of prosecution's case was unfair to prosecution, since the prosecution had indeed discredited those possible defenses in cross-examination of witnesses called by the accused by the time of judgment of the Court of Appeal. So basically, this is what is going on. This is what Godfred Dame the Akwakoto Supreme Court judges no enim. We wait to see. Let's see how the case will go. But I don't know. A lot of Ghanaians, and I mean, I'm not the one now saying latest Afrobarometer. Latest Afrobarometer, we are one year, and a lot of Ghanaians have lost hope in the judiciary, especially the Supreme Court. So let's see whether let's see how this. Anyway, we'll try I'll not be surprised, but let's see how this case will go.